All right, and are you Mr. Beltron?
Yes, Your Honor.
All right, in defense, you said you've adopted his motions?
Yes, Your Honor.
All right, so the first motion is a motion for a special appearance under the authority of Texas Rules of Civil Procedure 120A for the divine purpose of objecting to the de facto district court's abstract subject matter jurisdiction, non-ex parte third-party waivers allowed. So let's address that motion.
Yes, Your Honor. My client's position is that that there is a defect in the abstract subject matter jurisdiction, that he has been brought into this improperly because the state would be the plaintiff, and they brought him in and are litigating that, and that there's a jurisdictional issue that the court does not have in persona or subject matter jurisdiction.
All right, is there a response, Sate?
Judge, as a criminal district court, the court does have jurisdiction to preside over any matters. The defendant has been charged by indictment with the offense.
This wasn't just a motion. It was a declaration of war on basic courtroom procedure. But the judge wasn't having it.
Just presented to me, but looking on the face of the indictment, and I'm sure your attorney will tell you, an indictment is not evidence of guilt. It's just the means whereby a person is held over for trial, right? And so when a grand jury indicts a case, they're just saying there's enough evidence to hold you over for trial. They're not saying it's evidence beyond a reasonable doubt. And when information is taken to the grand jury or evidence, police reports or whatever it may be, and it has to be allegations that it happened in Bexar County, and it has to be allegations that it's a felony. Now, if this were not alleged to be a felony, then it wouldn't be in this court. Even though it would be a criminal case, it would be sent to a misdemeanor court maybe, or perhaps even a municipal court. But because aggravated robbery, according to the penal code, is a felony, it's supposed to be in a felony court. And then if they're saying it happened in Bexar County, then it would come to a felony district court, state district court that's in Bexar County. And that's where we are. You understand? Is there anything you not understand about my ruling on that? All right, thank you. And then we have, yes.
Excuse me, did the court take judicial notice of the indictment?
When the judge spoke, it was like a professor dismantling a conspiracy theory, methodical, factual, unshakable.
They're saying that the offense, that there is no subject matter jurisdiction because there's no injury by any party.
Yeah.
All right, so if you can address that.
Your Honor, this case was presented to a grand jury that was duly impaneled. They indicted the case. They returned a true bill of indictment. The indictment does comply with the penal code and the code of criminal procedure, which governs in this case. And it does allege the requisite elements for the aggravated robbery. And so it's a threat by using a deadly weapon. And so that is the harm. The crime was committed against the peace and dignity of the state, and there is an alleged complainant.
All right, so Mr. Beltron, do you understand with the charge of an aggravated robbery?
Beltron's logic? If no one is bleeding, there's no crime. The courtroom silence said it all.
The other issue, let me see. I don't understand when you say, explain it to me, you're saying district court is criminally attempting to receive an unauthorized, colorable, no-fault immunity? What do you mean by that? Because what I can tell you is I don't receive anything related to these cases. Of course, as a judge, I'm paid a salary for the work that I do, but I don't receive any funding or extra funding based upon how I resolve cases. Do you understand?
Yes, ma'am.
Do you have any question about that?
No, ma'am.
All right, so then the other one is dishonest services that rises to constitutional tort and national security concerns, communist activity detected in violation of Title 50 USCS 841, This court now under federal questioning.
You want to cross-examine the state of Texas? That line alone could win Courtroom Comedy of the Year.
Whenever you see cases on the criminal side, it's not individuals versus individual. Usually when you're on the civil side, if it's a marriage, it's individual.
Yeah,
If it's
please.
civil. All right, here, the reason why it's the state of Texas is because in criminal court, it's not you versus the complainant. Whoever the complainant is in this case that you're accused of committing aggravated robbery against, yes, it's alleged to have happened that you committed an aggravated robbery against them. But the state of Texas, the way we were taught in law school, the state of Texas takes offense, right? Because whenever an offense is committed against a citizen, it's the offense against the citizen, but it's also the offense against the state of Texas. So in cases such as these, the state necessarily is not the complainant. They're just bringing the suit or the case because the state of Texas is offended that an offense is alleged to have been committed within the state of Texas, within the county of Bear. So that's why the state of Texas is listed and not the complainant. Do you understand?
Yes, I understand that. And so how do I cross-examine the state of Texas?
The state of Texas,
Despite the chaos, the judge never lost her poise. This wasn't just justice, it was a masterclass in judicial patience.
Different that we need to bring to the court's attention that would be different.
all right.
Um,
So then with regards to that motion that's combined from page 1 to page 6, then the ex parte relief requested will be denied. Now, by denying that, that doesn't mean that if there's a jury trial, your attorney still will not have the opportunity to question whatever witnesses the state calls, okay?
Understood.
So that will be denied.
There is it appears to me that there was like 3 separate documents stapled together. Is that the way it was received?
Yes.
There is the next one, which is exhausting administrative relief.
Mhm.
My client is not wanting to have that heard, right? It deals with ineffective assistance of counsel. Right, Mr. Beltron, that's not to be heard right now?
All right,
Okay,
and let me explain something to you. I understand that's not to be heard right now, but what I can tell you is attorneys who are appointed.
Words like colorable immunity and abstract offense filled the air, but the judge didn't flinch. She saw through the fog.
so the next document is entitled Tort Constitutional Notice.
Mhm.
And that addresses antitrust violations, fraud upon the court, actions of the state bar.
All right, do you want to take these one at a time, counsel?
I guess so, Your Honor.
All right, the first is new discovery of antitrust violation lies, fraud upon the court, elected state bar officials, seditious organization are conspiring to fraudulently conceal the ultimate fact, Sixth Amendment misconduct that the state.
Conspiracies, communism, and constitutional collapse. Beltron brought it all. But the courtroom stayed anchored in reality.
And there has never been anything pre-indictment that was dismissed with prejudice with regards to these cases. All right, does that address that issue for you?
Yes, ma'am.
All right, then the next one, deceitful corporate veil and trumped up judiciary immunity is fatally pierced. I do not forfeit my privileges and immunities under the 4th and 14th Amendment. What I can tell you is during a jury trial, when the state calls their witnesses, your attorney will have a chance to cross-examine those witnesses. The rules of evidence do apply. If she finds that there is some question that is objectionable and should not be answered, then she will stand up, make an objection. Normally, the objections may be hearsay, entering the province of the jury, assuming facts not in evidence. It could be relevancy. It could be 404B. It could be any of a number of objections that she can make. Once she makes those objections, I will make a ruling, and my ruling will decide whether or not the witness can answer that question and whether or not the jury can consider it. Do you understand?
Yes, sir.
All right, does that address that issue?
Yes, sir.
I think the other issues deal, on the second page, deal with the State Bar, and I think the courts addressed that.
Okay,
The other one is gross advertising negligence of the DA's office.
okay.
And defendant being sued,
Oh, who's being sued?
the defendant.
All right. So, sir, there are different type of suits. There are civil suits. So technically somebody can be sued civilly for something. Sometimes with criminal cases, people will say, oh, it's a suit. Technically, it is sort of a suit, but it's again, the state of Texas versus whoever the defendant is. You understand?
Yes, sir.
All right. Do you have any questions about anything else? Okay. And then the next page.
In the eye of this legal storm, the judge gently reminded everyone, due process is still alive and well.
And then he say the plaintiff is in harmless artificial corporation. Are you talking about yourself or the state of Texas? Okay. All right. So whether or not it's a fishing expedition or a corporate entrapment or a Ponzi scheme, that'll be something that will be decided during the jury trial. Okay.
Yes, ma'am.
All right. All right. Is there any other motion that needs to be heard?
Anything else? Any other jurisdictional arguments that raised that we have not talked about and the judge has already ruled? Anything other than
No, no.
All right. Is there anything that you don't understand about the jury trial process?
With calm dignity, the judge brought it full circle, offering Beltron his constitutional right to a trial by jury.